Ladies and gentlemen, AERA's President, Joyce E. King.
Good evening. I'm Joyce E. King, President of the American Educational Research Association. On behalf of AERA, I welcome all of you joining us here at the Reagan Center and the hundreds more watching online to the 11th Annual Brown Lecture in Education Research. For those of you tweeting tonight's event, the hashtag is AERA Brown Lecture. We're pleased to provide complimentary Wi-Fi access. The network is AERA 2014. The password is 102314. We also ask that all of our guests please silence their cell phones. For those of you who may be unfamiliar with AERA, the American Educational Research Association was founded in 1916. AERA is the largest national scientific and scholarly society dedicated to advancing knowledge about education, to encouraging scholarly inquiry related to education, and to promoting the use of research to improve education and serve the public good. AERA publishes the top-ranked journals in the field. Let me take this opportunity to invite all of you to attend the 2015 annual meeting in Chicago this coming April. The theme this year is Toward Justice: Culture, Language, and Heritage in Education, Research, and Praxis. The theme, in many respects, captures the purposes of the Brown Lecture. We have the opportunity and the moral obligation to apply principles and evidence from social science research and theorizing to the problems of injustice. And we must consider how education praxis, research, theory, and policy can change the world toward more justice. In 2004, AERA inaugurated what has become known around the country as the Brown Lecture, not only to commemorate the U.S. Supreme Court's landmark decision in Brown v. Board of Education, but also to acknowledge that the best and the boldest of social scientists at the time were bringing innovative ideas and methods to efforts to understand the persistent problems of racial inequality in society. The Brown Lecture is an annual reminder of the important role that research can play in advancing equality in education. Each year, a distinguished scholar, notable for producing significant research related to equality in education, delivers the Brown Lecture. With the 2014 and 2015 years marking major anniversaries of landmark moments in the American struggle for equality, the 60th anniversary of Brown, the 50th anniversary of the 1964 Civil Rights Act, the 50th anniversary of the Voting Rights Act of 1965, and the 150th anniversary of the 13th Amendment, it is appropriate that our lecturer is a noted expert on American education history and desegregation. Tonight's lecture would not be possible without the generous support of the 13 friends of the Brown Lecture, and I would like to acknowledge them and their generosity. American Institutes for Research, American Political Science Association, American Sociological Association, Association for the Study of Higher Education, College Board, Council for the Accreditation of Educator Preparation, ETS, George Washington University Graduate School of Education and Human Development, History of Education Society, SAGE, Spencer Foundation, University of Illinois at Urbana-Champaign College of Education, University of Maryland College Park College of Education. Thank you, our friends, for your continued commitment and support. I would also like to acknowledge and thank the Brown Lecture Selection Committee for its work. The committee included AERA Executive Director Felice Levine, Selection Committee Chair Estella Ben-Simon, Tandika Chapman, Django Paris, AERA Past President Barbara Snyder, AERA Director of Social Justice and Professional Development George Wimberly, and myself. And now I invite Estella Ben-Simon, Professor of Higher Education and co-director of the Center for Urban Education at the Rossier School of Education at the University of Southern California and chair of AERA's Social Justice Action Committee, to introduce this year's distinguished lecturer. Estella?
Good evening. On behalf of the Selection Committee and the officers, leaders, and members of AERA, I am honored to introduce our 2014 Brown Lecture presenter, Professor James Anderson. On this 60th anniversary of the Brown decision, it is impossible to imagine a more fitting presenter than James Anderson, an insightful social scientist and nationally recognized expert on American education history and desegregation. Professor Anderson is the Gutzgill Professor of Education at the University of Illinois, Urbana-Champaign. His scholarship focuses on the educational history of African Americans in the South, desegregation in schools, colleges, and universities, and more recently on affirmative action in colleges and universities. Dr. Anderson was elected to the National Academy of Education in 2008, and in 2012 he was selected as a fellow of the American Educational Research Association. Professor Anderson is a model of the public intellectual to which we all aspire. His scholarship and powerful historical chronicling of the African American struggle for the right to excellent education has reached millions of people through his participation in several PBS documentaries, among them School, The Story of American Public Education, The Rise and Fall of Jim Crow, and Forgotten Genius, The Percy Julian Story. His scholarship has penetrated the highest levels of our legal system. He served as an expert witness in the most important legal cases impacting equality and equity since Brown versus Board of Education, Gratz versus Bollinger, and Grutter versus Bollinger. There are many aspects of Professor Anderson's remarkable career as a historian, scholar, educator, and intellectual activism that I could highlight. However, I would be remiss if I did not single out for special attention his book, The Education of Blacks in the South, 1860 to 1935, which won the American Educational Research Association Outstanding Book Award in 1990. This book is about the educational experiences of blacks during the 75 years immediately after the Civil War. Anderson accomplishes two things in this book that are as relevant for the past as for today, and that we should take note of. He exposes the myth that Northern philanthropists had altruistic motives in promoting the education of blacks. Anderson's account shows that support for the education of Southern blacks was motivated by the need to have a predictable supply of labor, or as we say today, workforce development. Second, contrary to common beliefs, Anderson details the extraordinary sacrifices blacks made in order to establish schools in a society that taxed them for public education but returned practically nothing to them. There is no one better qualified than Professor Anderson to take a sweeping view of this history and its lasting legacy. Please join me in welcoming the 2014 Brown Lecture in Education Research speaker, Professor James Anderson.
Good evening, and thanks for coming out. I want to thank Estella Benjamin for the wonderful introduction. You always hope that you could be half as good as your introduction. I also want to say thanks to the Social Justice Committee for bestowing this honor on me. When Barbara Snyder called me and said she had good news, I had no idea what she was talking about. I thought it was another committee appointment. And I was wondering how it could be good news. Also, I want to thank the support of the AERA staff. Felice Levine, who is a friend and colleague, has been extremely supportive. And I also want to give a special thanks to Tony Pals, who has been invaluable. If I told you that he's picked me up every time I fell down, you would think that I'm speaking metaphorically. But this morning, I literally fell down the steps in the AERA office, and he picked me up. But if you're ever in the position to have to give this talk, contact him first, and he will guide you through. He'll make you better than you thought you could be. I'm also thankful for the many friends and colleagues and former students who've come out this evening. That is always a special feeling and a special sense of gratitude. And there's a particular delegation here from Illinois, lots of people. You always feel very warmly supported and encouraged when your fellow faculty and students come from Illinois, and we have quite a group here, so thank you for coming. And to my fellow historians back at Illinois, Yoon Park and Chris Spann, I think they had something to do with this, I don't know, but I want to thank them, and I want to give a special thanks to Chris Spann for helping me with my first PowerPoint presentation. And also to his son, Langston. We were in the office on Sunday and spending all day, and Langston indulged us the whole time. And he was very good, and I'm very appreciative of him allowing me to steal his dad for a whole day. The presentation this evening focuses on two interconnecting themes: equality of political rights and education equality. More specifically, I look at the historic and inseparable relationship between the right and freedom to vote and its impact on the pursuit of education equality. The presentation begins by explaining how the choices made by the Reconstruction or the 39th Congress regarding the right and freedom to vote cast a long shadow over our nation's historic pursuit of equality from then until now, and also threatens the nature and content of democratic practices for generations yet unborn. The second and interconnecting theme illustrates the powerful relationship between equality of political power and education equality by examining the developments of African American education in the 3 decades, roughly 1868 to 1888, or 1898, between emancipation and the rise of Jim Crow schooling at the turn of the 20th century. Prior to the rise of Jim Crow schoolings, there were 3 decades in which African Americans, as voters and lawmakers, coalesced with Republicans and some white Southerners to blaze a fundamentally different pathway toward education equality and social justice. By reaching back into the decades before Jim Crow schooling, we are able to observe an alternative vision of democratic practice and a different relationship between government and the distribution of educational resources. The analysis of this period of relative equality is followed by a brief comment on the state-mandated segregation and inequality between 1900 and the Brown decision. This system, known to us as Jim Crow schooling, stands in sharp contrast to the post-emancipation movement toward political equality and education equality. The door to separate and unequal, specifically the unequal side of the equation, was opened not so much by Plessy v. Ferguson as by the manner in which the 39th Congress framed the meaning of equality in the post-Civil War amendments. They framed it in a way that continues into our own present with corrosive effects on the quality of democratic practice. It all began here in the Capitol on December 4, 1865. It was a momentous occasion for the 39th Congress, their opening session. The Civil War had ended, and they were meeting for the first time. Scholar Colfax of Indiana had been elected Speaker of the House, gave a long and eloquent talk about the responsibility of the new Congress to guarantee to every state a Republican form of government and equal rights to all citizens. And then there was an interruption. Benjamin Washburn, a congressman from Illinois, was asked by the Secretary of State, William Seward, to read a telegraphic message that had come from Lewis E. Parson, who was the provisional governor of Alabama. The message read as follows, quote, "The amendment is adopted by an overwhelming vote. I will send you an authenticated copy at an earlier date. Please see that Alabama is announced as the 27th state." The reading of the resolution was followed by applause in the halls of Congress and in the galleries, because everyone knew what it meant that the 13th Amendment to the Constitution would be ratified, and 2.5 centuries of slavery finally abolished by the Constitution of the United States. The pending ratification of the 13th Amendment focused the 39th Congress on its most pressing obligation, the only part of the Constitution that they were compelled to amend, and that was to repeal Section 2 of Article 1 of the U.S. Constitution, or the Apportionment Amendment, that determined the number of seats that each state would have in the House of Representatives. Under the Constitution, the seats were determined by the following formula: a counting of free persons, excluding Indians not taxed, which accounted for 90% of the Native American population, and 3/5 of all other persons. All other persons was simply a euphemism for slaves. The 13th Amendment abolished the 3/5 clause of the Constitution. Now that all other persons had become free persons, it presented some very serious challenges to the Congress. One, they knew that now that the former slaves were being counted as free persons, it would add 10 seats to the House of Representatives from the former slaveholding states. They also knew that in all likelihood, those states, once readmitted to the Union, would exclude those voters, exclude those newly emancipated free persons from the elective franchise. And so it was quite a challenge to the Congress. On December 4th, the first day, Charles Sumner, the leading advocate of equality in the Congress, both House and Senate, proposed an amendment to the Constitution to guarantee equal rights to all citizens. The following day, December 5th, Thaddeus Stevens out of the House proposed the following amendment to the Constitution: all national and state laws shall be equally applicable to every citizen, and no discrimination shall be made on account of race or color. And this was the first version of the 14th Amendment, very different than the one that finally ended up in the Constitution, and I'll explain as I go. The next day, John Bingaman of Ohio, congressman, introduced another resolution, another 14th Amendment. It read, to empower Congress to pass all necessary and proper laws to secure to all persons in every state of the Union equal protection in their rights, life, liberty, and property. Since control over the elective franchise had rested in the hands of the respective states since the Constitution was framed in 1789, the proposed amendments to the Constitution taken together meant that Congress would exercise unprecedented power over the right and freedom to vote. And more important, the right and freedom to vote could not be abridged along the lines of race or color. as they put it. All proposed amendments were submitted to the Joint Committee on Reconstruction. It was a newly created committee, and it had the responsibility to take all amendments, all legislative acts, and all resolutions, and to vet them through an in-depth examination, and then bring them back to the floor of the House and the Senate to amend the Constitution. The proposed amendments came back as one amendment on January 22nd in 1866. It stated that wherever the elective franchise shall be denied or abridged in any state on account of race or color, all persons of such race or color shall be excluded from the basis of representation. Now that's a mind twister. This version represented a fundamental change from the original proposals that were introduced in late December of 1865 and early January of 1866. Thaddeus Stevens explained the difference. Quote, "It does not deny to the states the right to regulate the elective franchise as they please, but it does say to a state, if you exclude from the right of suffrage Frenchmen, Irishmen, or any particular class of people, none of that class of persons shall be counted in fixing your representation in the House. Rather than preclude the states from discrimination, the proposed amendment would punish them after they had discriminated." Charles Sumner was positively apoplectic with anger and disbelief that his party would propose an amendment to the Constitution allowing states to disenfranchise voters on the basis of race or color, even if it proposed a penalty, the reduction of seats in the House for doing so. He spoke for 4 consecutive hours against the proposal and ended with the following proclamation to his fellow congressmen, quote, "Equality is the alpha and omega in which all other rights are embraced." He then proposed a different version of the 14th Amendment, and it read, "All the elective franchise shall not be denied or abridged in any state on account of race or color." The yeas and nays were taken, and the result was 8 votes in favor and 38 against. Although the different versions of the 14th Amendment were returned to the Joint Committee for final vetting, the vote on March 9, 1866 signaled the end to the strong hope that Congress would protect the right and the freedom to vote. The proposed amendments were held within deliberation of the Joint Committee after that for 75 days, and they were held in secret. They returned to the Congress again in late May 23rd of 1866, and it was a different committee, a different proposal, a different amendment. The committee had snatched victory from the jaws of defeat. What they did was to transport critical sections of the 1866 Civil Rights Act into the 14th Amendment and give us the amendment that we now know that defines citizenship, allows for due process, and equal protection under the law. No one knew the minutes from inside the committee, so Senator Harwood, Jacob Harwood, gave the Congress an explanation as to why the Joint Committee changed the 14th Amendment from its original proposal to the one that we now have. In Howard's words, quote, "The committee were of the opinion that the states are not prepared to sanction so fundamental a change as would be the concession of the right of suffrage to the colored race. We may as well state it plainly," he said, "and fairly, so there shall be no misunderstanding on the subject. It was our opinion that 3/4 of the states of this union could not be induced to vote to grant the right of suffrage, even in any degree or under any restriction to the colored race," end of quote. Howard continued his explanation thusly: "The amendment does not recognize the authority of the United States over the question of suffrage in the several states at all, nor does it recognize, much less secure, the right of suffrage to the colored race." Bingham of Ohio considered this to be the final and penultimate draft of the 14th Amendment, and it was. The authority of the states to fix the qualification of voters was ratified in the 14th Amendment in 1866 and remains with the states in 2014. Now, I turn to a disjunction between Reconstruction and the rise of Jim Crow schooling at the turn of the century. Fortunately for the newly emancipated African American citizens, historical developments rarely move in a straight line, and the history of disenfranchisement and enfranchisement is no exception. The seeds of disenfranchisement planted by the 39th Congress would not bear strange and undemocratic fruit until the turn of the 20th century. Meanwhile, over the next 3 decades, African American voters and office holders were active participants in shaping both conceptions of equality as well as the legal and administrative framework for implementing their vision of equality in political rights and education. For an illustration of how that unfolded, we now turn to the South in general, where more than 90% of the African American population resided in the post-emancipation period, and in particular to the state of Alabama, for a kind of historical case study. More specifically, the case is developed on the evidence from the Black Belt counties of Alabama, roughly from 1870 to 1900. So I'm literally taking you home, since I was born and raised in the Black Belt, but I promise not to leave you there. If you look at the map of the Black Belt counties, and if you look at, then we go to table 1, and I'll give you an explanation, because these counties were very, very heavily populated by African Americans, and is known as the Black Belt, not so much because of the color of its people, because most of the counties, indeed, a vast majority of them had black populations above 70%. And they had that in 1870, and also they had that in 1910, as I look across the board. But anyway, it's known as the Black Belt because of the very rich black soil that is fantastic for growing cotton. And so when slaveholders brought their plantations into the Black Belt, they brought with them thousands of slaves, and when those slaves became free persons, they were the dominant populations in that area. Now, I first sort of got a sense of this from an article by Horace Mann Bond that was published in the inaugural issue of the Journal of Negro Education. And in that issue, Bond had talked about a period of relative equality. And he started by saying that in 1890, that African American students in the state of Alabama, who were 43% of the total school population, got 44% of the school funds. And when I first read that, it was so counterintuitive, both in terms of my memory as well as historical scholarship on the period. And I was thinking, how could they have more equality in 1890 than we had in the 1960s? It just seemed strange. It just seemed so counterintuitive. So in order to satisfy myself as to whether Bond's suggested probes were actually empirically based, I decided to do a case study of the counties in the Black Belt. And I looked at several things, including school enrollment, the distribution of the school's fund, length of school terms, teacher salaries, and the kinds of things that were used to measure equality in the late 19th century, the post-emancipation period. Table 1 shows the percent in the populations, and you can see that these populations are majority black across the board. Table 2 gives you the percentage of the school-age population. And if I could draw your attention to Sumter and Wilcox County at the bottom, it sort of gives you a sense of the period of relative equality versus the rise of Jim Crow schooling. In 1877, for example, they both had a 35 and 27% school enrollment. If you move forward to 1915, you can see that school enrollment in 1915 was much lower than it was in 1877, even though in the years in between it had gotten up to 55%. But in 1901, things changed at the 1901 Constitutional Convention when the Redeemers, or the Democrats, reclaimed control of the region, and I'll come back to that issue. Another measure is the length of public schools, the average length of public school days. In 1877, African-American students have a +2. In 1887, a +16. In 1897, it's a -2, but by 1915, it's a difference of a -54 days in schooling. Again, once the Democrats took control of the legislation, a different conception of equality as well as a different administration occurred. Teachers paid. Black teachers were making more than white teachers in 1877 in most of the counties. By 1915, you can see that white teachers make more than them, a substantial bit more in every one of the counties. Table 5 is simply a look in 1882 at the distribution of the school funds. And you can see in most of these counties where there is an African-American majority, they're also getting a substantial majority of the money that is given to the county in that. Now, this all ends with the 1901 convention, which is held in Montgomery. And that convention, and one of the reasons that was relative equality, because in the 1868 conventions, African-American delegates and lawmakers had put into the provision for school funds that the school funds in the state of Alabama would be divided on a per capita basis and for the equal benefit of all children. And that was demonstrated in the distribution of those funds in a 30-year period from 1877 all the way to 1897. It changed in 1901 with the 1901 convention. In that convention, the phrase the benefit for the equal benefit of all children was taken out of the Constitution, and put in its place was the clause just and equitable. Now, so that no one would be confused as to what the 1901 delegates meant by just and equitable, they were quite open as to what they meant. One delegate said the following, quote, "Under the present laws of Alabama, if the law is carried out, the colored pupil gets the same amount of money per capita as the white pupil, and that is not justice." And you can see with the new political dominance, a very different conception of justice, a very different conception of equality is now in place. Probably the most important thing that happened in the 1901 convention was the disenfranchisement of African American voters, the very basis of them participating in the government in the post-emancipation period and being able to really fight for successfully a different and alternative path toward equality. At the 1901 convention, they passed all kinds of voting restrictions to disenfranchise the African American population. By 1905, 4 years after that convention, only 3,654 out of 181,000, or 2% of the state's voting age African American population was registered, compared to 278,000 out of 224,000, or 91% of the state's voting age white population. This kind of disenfranchisement and its resultant impact on education equality extended to and beyond Brown v. Board of Education and into the middle of the modern civil rights era. One thing that Plessy and Brown had in common is that they both were handed down in a context where African Americans had been disenfranchised. So in both cases, the implementation of Plessy plans, the separate but equal plans, and the implementation of the Brown plans, that is, a separate and the separate was inherently unequal, were both handed down in the context where African Americans had no political power and no leverage to shape the implementation of those plans. If we move forward into the 1960s, you can see, we'll see that the disenfranchisement in the 1960s was least removed from the disenfranchisement in the early part of the 20th century. We look at the registered voters in the Black Belt counties in 1960. Now, as a consequence of the violence around voter registrations in the civil rights movement, the Department of Justice had gone in to investigate the status of voter registrations. And they filed reports on all the states. And I was able to pull out of those reports on Alabama what the conditions were like in the Black Belt counties in the 1960s. You can see that in some of the counties, like Lowndes County and others, that there were 0 African Americans registered to vote. Not a single person was registered to vote in 1960. You also can see, and speaking of voter fraud, that in a number of those counties, the white registration is above 100%. And given the findings of this, the Attorney General, Nikolas Cassadine, was getting these reports, and he sent a memorandum to President Johnson to deal with the situation, which was a catastrophe. And he gave a number of solutions to resolve this in the order that he preferred them. Number 1 on his list was the following: a constitutional amendment to prohibit the states from imposing any qualifications or disqualifications for voting in federal or state elections other than age, 2, a short period of residence, 60 or 90 days, conviction of a felony, or commitment to a mental institution. That those would be the only restriction placed on voting, and the amendment would give that protection to Congress to protect every individual's right to vote. As we know, instead of following Kassenbach's recommendation to amend the Constitution for federal protection, Congress chose to pass the Voting Rights Act in 1965 and to behave almost exactly like the 39th Congress, leaving the authority of fixing voter qualifications to the states, except for a pre-clearance requirement that was gutted by the Supreme Court, and of all cases, Shelby County, Alabama versus Holder. Consequently, in 1968, when court-ordered school desegregation finally came to the South, many black professional educators feared that the region's conservative Democrats would use their unequal political power to implement what they call, and I give credit to Vanessa Sitter Walker for this phrase that she learned from her professional educators that she studied, a second-class integration. Such concerns are well documented in her work. And the professional educators who were worried about a second-class integration soon found that their fears were not without solid foundation. The manner in which Southern states and local governments implemented school desegregation plans devastated black leadership and also ended the careers of tens of thousands of African-American teachers and administrators. Throughout the region, school desegregation eliminated an entire generation of black principals and teachers. An estimated 38,000 teachers and administrators lost their jobs between 1984 and 1989. Another 21,000 or more lost their jobs between 1984 and 1989. In North Carolina, for example, from 1963 to 1973, the number of African-American principals in the state's elementary schools plunged from 620 to 170. Even more striking, 209 African-American principals headed high schools in North Carolina in 1963, but less than 10 headed that position in 1970. By 1973, only 3 black principals had survived the process of wholesale displacement. Such treatment spoke volumes about the long-standing disenfranchisement of black voters and the absence of African Americans in state and local government. They had neither the votes to leverage a different outcome or the political power to compel alternative plans of desegregation suitable to the interests of African American communities. Now, to be sure, the post-Brown years witnessed educational progress in critical areas, as had been documented in the excellent work of Gary Orfield. It increased high school graduation rates, college rates, and also increases on standardized tests. But even Orfield, in the most recent report, says that one cannot help that we are now witnessing a long retreat from the gains of the 1980s, as well as an uncertain future. One cannot help but be struck by the gains in education equality between 1870 and 1900, followed by a long retreat and a substantial increase in education inequality that corresponded loosely to the disenfranchisement of voters and lawmakers that spearheaded the campaign for equality in the post-emancipation period. This raises a serious question as to where we are today on contemporary disenfranchisement campaigns and whether they will also have an impact on the struggle for education equality into the future. Since around 1906, we have witnessed systematic campaigns to impede voters at every step of the electoral process. In 2011, 38 states introduced legislation to constrain and obstruct universal suffrage. Florida voter suppression law curtails early voting and leaves off the final Sunday before election, when many African American churches collectively bring their voters to the polls. How significant is that? On the final Sunday in the 2008 election, presidential election, for example, African American voters accounted for 1/3 of the total votes cast nationally on the Sunday before the election. The elimination of that Sunday has a very adverse impact on their voting, their freedom to vote. Although the proponents of photo identification, proof of citizenship requirements, registration restriction, absentee ballot, and reductions in early voting claim the existence of significant voter fraud as a reason for such measures, this has proven to be a false claim. John Levitt, in a study of 1 billion votes cast local, state, and federal election over the last 14 years, of 1 billion votes, there are only 31 cases of impersonation fraud out of 1 billion votes. Still, the Supreme Court recently approved the voter ID law in Texas, Senate Bill 14, as non-discriminatory. Justice Ginsburg said in her dissent, "The recently upheld Senate Bill 14 in Texas may prevent more than 600,000 registered Texas voters from voting in person for lack of compliant identification. A sharply disproportionate percentage of those voters are African American or Hispanic," end of quote. Since there is virtually no evidence of voter fraud, are we seeing echoes of Reconstruction in the most recent effects of the long shadow? In a careful study of this question as to why states consider and adopt restrictive voter access policies, Bentelli and O'Brien conclude the following: the recent wave of restrictive access legislation is rooted in long-standing racial and classist motivation, revived for modern deployment. If we look at adults without a valid ID today, we can see that the results are significant. 1 in every 4 African Americans nationally would not have the ID. Almost 1 in every 5 Asian and 1 in every 5 Latinos would not have the ID, and therefore would not have the freedom to vote. And that does not even get to the questions, others related, incarceration and so forth, and restrictions on voting. Where do we go from here? After reading through the debates, actions and inactions, and then thinking about the long shadow that the Reconstruction Congress cast over the pursuit of equality in America, I still come to the conclusion that they had it right in the first place, just not the courage to act on their most noble ideals. What Charles Sumner proposed in 1866, as well as what Nikolas Cassadine proposed in 1960, remains the best solution to our long history of voter disenfranchisement and the impact of disenfranchisement on education equality. And that is, make the right and freedom to vote a constitutional guarantee that cannot be infringed upon by the states. To quote a favorite poetic line that the late Robert Kennedy borrowed from George Bernard Shaw, "Some people see things as they are and say, why? I dream things have never been and say, why not?" Why not a nation? Why not in a nation which the right to vote and the freedom to vote, that is, the qualifications to vote, are secured by an amendment to the Constitution of the United States? How does the world's oldest democracy, as we are so fond of saying, stand helplessly watching Texas, Pennsylvania, North Carolina, South Carolina, Florida, and other states enact, literally rig the qualifications of voting so as to disenfranchise millions of voters. This is going to become apparently what seems like to be a different problem as we go forward. We see the important demographic changes. Projections now in the next 40 years, the American population will be 35% Latino, 43% white. And people are saying, well, will these demographic shifts finally change all of this? And I go back to the post-emancipation period, when Louisiana was majority black, Mississippi was majority black, South Carolina was majority black in those years. And they tried to foster an inter-ethnic coalition of democratic government. And that was one alternative path that was crafted in the 3 decades following emancipation. But yet the fears of an inter-ethnic democracy, and the fears of losing power, and the fears of losing the country, instead of creating and embracing diversity in an inter-ethnic democracy, led to the opposition and the disenfranchisement of the very voters who had tried to foster an inter-ethnic democracy. In the future, will we see an embracing of a diverse America, allowing all people to vote and creating an inter-ethnic democracy, and also the enfranchisement of all people that I think, when they're at the table, will help with their pursuit of education equality? Or will we see what we saw in the post-emancipation period? Fears of a different country, fears of changing, and instead of working with all Americans, including new immigrants, they actually seek to disenfranchise and to divide. We're on that course, and what I take from history, and really I didn't go into a lot of details, but the senators and congressmen who had wanted to change the Constitution and to protect everyone's right and freedom to vote had a deep foreboding about the inability to do it. They saw it as a propitious moment to reinvent democracy, to take what they call the Declaration of Independence, the organic law of the nation, and incorporate equality into the body of the Constitution, and they were unable to do what they really wanted to do because of the politics and the quest for power and different kinds of coalitions. But the choices they made cast a long shadow. People are being disenfranchised today because of their failure to protect the right and the freedom to vote in 1866. And what I mean by that is that the right to vote is one thing. The freedom to vote means that the states are the one who fix the qualifications. You don't have the freedom to vote when they put in all of these restraints. And so now we're at another moment. The country is changing, and we have to make decisions about immigration, about the dreamers, about the way forward. Will this Congress, will this nation make the right choices to move forward with a democracy in which we can all live and work together, or will it cast a long shadow over generations unborn? Thank you.
Thank you, James, for your substantial contributions to education research and the history of education. And thank you especially for your insightful and inspiring lecture. We look forward to spreading the word about the webcast of this lecture on the AERA website and reading the published article in an upcoming 2015 issue of AERA's journal, Educational Researcher. We hope that all of you will plan to attend next year's Brown Lecture, which will be held October 22nd, 2015. And please remember the open invitation to attend the AERA annual meeting in Chicago April 16th to 20th. The 2015 annual meeting theme focuses our attention on justice locally and globally. We thank you all for joining us at this important lecture. We invite you to sign the guest book in the foyer, which we will give to James as a remembrance of this special occasion. Now we invite you to the reception in the foyer outside this auditorium. Thank you, and thank you again, James.